because we were able to work together. And this, I'm going to loop back to my original point, which I didn't quite finish. When you're a collaborative attorney and you've signed the participation agreement and you are engaged as for the limited purpose of helping someone settle, and you're not helping them in mediation in the shadow of litigation, but you're solely devoting your time, attention, and skills to helping them be successful at the negotiating table, that changes the dynamic. And if Ms. Pence and I have a case together,
how does it change the dynamic?
Because my sole job is to help you settle. Now, I may help you evaluate the settlement too, but I don't have to keep one foot in the, but if the case doesn't settle, what am I going to do? How is this going to look in court? What if they're not truly engaging in the settlement process for the purpose of settlement, but they're just trying to fish out information, or they're trying to be strategic? And I have to keep my mind on, if we end up in court 2 weeks from now or 3 weeks from now or 3 months from now, how is this going to affect your case? How is this going to affect what we do? There is a difference in the dynamic at the table, and it affects, for instance, Ms. Pence and I, if we have a case together, we can communicate and we can work together in a way where I can say to her in a different way, here's what my client really needs, and here's what she's really interested in. Here's what her underlying interests are, and this gets to that interest-based negotiation. Here's what her two interests are, and she's not going to be able to reach a settlement until these interests are met. That just doesn't happen in negotiation that's in the shadow of litigation, at least not in the same way.
Yeah, but something you said, you may not, under the collaborative process with this Uniform Act, you could not go on to represent your client in litigation.
That's right. That is.
But if you are, but if the other side isn't really in good faith, you still have an ethical duty to your client to be protecting them in litigation. You won't be involved in the litigation, so you won't be thinking about how to litigate the case because you won't be litigating the case. But you still have to be mindful if it.
You're right. You're right. And we're mindful of it, and we talk openly about it. We talk openly about, if this case is not successful, what will that mean? And we talk about it with our clients, and we may even talk about it with the other party and the other attorney at the table. So you bring it out into the open, and once you bring it out in the open, that's where some of the creativity happens, and some of the problem solving really comes into play.
All right, something that you said was that this process is not for everybody. Mm-hmm. That people who have a dispute have to choose which process is best for them: arbitration, mediation, litigation, right, or collaborative.
Or just roundtable negotiation, or sometimes parties just want to keep dealing with each other directly and they have their attorneys in the background, just helping them know what the issue is, understand how the law may affect it. There's lots of different ways.
So if this process is right for a couple, what the bill does is it gives them, I guess to use the phrase Ms. Pence had, a minimum, a floor with regard to, there's some definitions, there's some minimal requirements with regard to confidentiality, privilege, and so forth. So it gives them that. But if this process isn't right for a couple, they're just going to get chewed up with some expenses, and we haven't done anything that they couldn't have done under mediation or.
Well, so what happens is when a client comes to you, they don't come to you necessarily as collaborative. They come to you with a problem, and you're an attorney, and they're coming to you and saying, can you help me solve this problem? And one of the first things you do is you say to them, so what's going on? And you get an understanding of what's going on in their lives and what the issue is. And then one of the things that you do, whether there's collaborative or not, whether there's the Collaborative Law Act or not, is you help them figure out what process should you use to try and address this issue that you're having. Should we reach out to the other side? Shall we go file papers immediately? What should we do to help you solve it? So that's the first step, is when you're describing the various processes, you include collaborative process as one of the processes that you describe to them, that you inform them about, and then you help them make a decision about whether this is right for them. And in helping them make that decision, what the law says and what you ought to be doing anyway is informing them about what's different about collaborative. And one of the things that's different about collaborative is if once you enter the process by signing the participation agreement, the case doesn't settle, or it only settles some of the issues and not all the issues. Once I'm your collaborative counsel, I can't represent you in another adversarial process to resolve that last issue or resolve the case. And that is different, and they need to know that. And what the Uniform Collaborative Law Act does is it says that clearly and plainly and puts the obligation on the attorney to make sure that when someone signs the participation agreement, that they understand that and they have that information, so the consent truly is informed consent. And then it also sets minimum standards, as Ms. Pence said, about what has to be in the participation agreement. So when they sign that participation agreement, that contract is clear and it spells out those essential elements, the disqualification provision, that the conversations in the collaborative process are privileged. And then, what happens if the case does terminate, that you will have to get a new attorney.
Of course, the conversations are privileged under the other alternative.
There is a general privilege regarding settlement negotiations. And,
So
we're practicing right now, collaborative practice.
You very promptly.
Okay. Well, I appreciate the answers you all have given me and your testimony. So if I do think of any other questions, but I've worked hard at thinking of every question I could come up with.
All right.
Thank you.
Thank you.
So then this concludes the hearing. This has been a hearing on two bills, Bill 18-821, Marriage Officiant Amendment Act of 2010, and Bill 18-829, the Uniform Collaborative Law Act of 2010. As I said, the record will close at 5 o'clock p.m. on October 21st, 2010. The time is now 4:35, and this hearing is adjourned.